1 minute ago, federal marshals arrived at the gates of Mar-a-Lago, carrying something that no law enforcement officer has ever delivered to a sitting president's private residence in the 235-year history of the American Republic. Grand jury enforcement orders, not subpoenas, not requests, not invitations to cooperate voluntarily with an ongoing investigation. Enforcement orders. The specific legal instrument that a federal court issues when a party has received a grand jury subpoena has failed to comply with that subpoena within the required time window and has exhausted every available legal mechanism for delaying or avoiding compliance. Enforcement orders mean the time for legal argument is over. They mean a federal judge has reviewed the subpoena, reviewed the noncompliance, reviewed the privilege claims, and concluded that none of the legal arguments advanced by the non-complying party is sufficient to justify continued noncompliance. They mean the party receiving the enforcement order must produce the demanded documents and testimony now, or face immediate contempt of court proceedings that carry daily financial penalties, and for individuals who are not the sitting president himself, the possibility of incarceration. I am going to give you the complete picture. What the enforcement orders demand, which of the previously subpoenaed parties triggered them through noncompliance, what is happening at Mar-a-Lago right now is the federal marshals wait at the gate for a response that the president's legal team is frantically trying to formulate, and exactly what this moment means for the Supreme Court oral arguments that are now 13 days away, for the grand jury's expanded insider trading investigation, and for the constitutional question that has never been answered in American law, because it has never previously been necessary to answer it. Can a federal court enforce a grand jury order against a sitting president's private residence? Subscribe right now. Federal marshals at the gates of Mar-a-Lago with grand jury enforcement orders is not a legal development. It is a constitutional moment. And the answer that comes out of those gates in the next few hours will define the relationship between presidential power and the rule of law for the next generation of American governance. Let me start with what triggered the enforcement orders, because the sequence of non-compliance that produced this moment is as important as the moment itself, and the media is reporting the arrival of the marshals without giving you the documented legal history that made their arrival inevitable. The original subpoenas were issued 21 days ago to the 4 senior officials I identified in my earlier analysis: the National Security Advisor, the Secretary of Defense, the CIA Director, and the White House Chief of Staff. All 4 asserted executive privilege across all demanded documents and refused production within the 21-day response window. That refusal triggered a motion to compel filed by the grand jury's prosecutors in Judge Holloway's court. Judge Holloway heard arguments on the motion to compel 8 days ago. She issued her ruling 4 days ago, a 41-page order that methodically dismantled every executive privilege claim advanced by the administration's legal team and ordered production of all subpoenaed materials within 72 hours. The administration filed an emergency appeal of Judge Holloway's production order to the appellate court. The appellate court, the same court that issued the unanimous 11-0 ruling on the war powers question, denied the emergency appeal within 18 hours. The administration filed an emergency application to the Supreme Court seeking a stay of Judge Holloway's production order. The Supreme Court, which had already rejected 2 emergency applications from this administration, denied the stay application without recorded dissent. Without recorded dissent, not 6-3, not 5-4. The Supreme Court denied the stay of the document production order without a single justice recording a dissent. That procedural outcome tells you something more significant than any of the previous 6-3 rulings. When not a single justice of the Supreme Court was willing to record a dissent from the denial of a stay, it means the legal arguments advanced by the administration for refusing document production were so weak that even the 3 justices who have consistently dissented from adverse rulings in this case concluded that those arguments did not merit a recorded objection. The 72-hour production window in Judge Holloway's order expired 14 hours ago. No documents were produced. No testimony was provided. No compliance of any kind occurred. Judge Holloway signed the enforcement orders at 6:47 this morning. The federal marshals arrived at the gates of Mar-a-Lago at 9:22 a.m. They are there right now as you watch this. Let me give you what the enforcement orders specifically demand, because their scope reveals the full extent of the document production that the administration has been refusing, and the legal exposure that continued refusal creates. The enforcement orders cover 5 categories of documents across the 4 original subpoena recipients. The first category is all communications between the National Security Council and the Office of Legal Counsel regarding War Powers Resolution compliance from January 1st through the present date. This is the category that will document the 3 OLC memoranda warning about the 60-day limit that I identified in my earlier analysis, and that were provided to the National Security Advisor between day 41 and day 58 of the operation. The second category is all communications related to the decision not to disclose the Iranian back-channel offer to Congress, to allied governments, or to the Supreme Court during the emergency application proceedings. This is the category that will document the May 7th meeting at which the concealment decision was made, and that the Supreme Court's good faith finding identified as the source of the material omission from its first emergency application. The third category is all financial records, communications, and transaction documentation related to the 3 Delaware LLCs incorporated between November 2025 and January 2026 that were targeted by the overnight subpoenas I described in my previous analysis. This is the category that connects the War Powers investigation to the insider trading investigation, and that has produced the most acute legal concern inside Mar-a-Lago in the past 48 hours. The fourth category is all communications between anyone present at Mar-a-Lago and any individual outside the administration regarding the strategic direction or operational parameters of the Iran operation during the period from January 1st through the present date. This category is specifically designed to capture communications that occurred at Mar-a-Lago, rather than in the White House, and that therefore may not be protected by the executive privilege claims the administration has been asserting over White House communications. The fifth category is the personal attorney's communications with the president and with any other individual present at Mar-a-Lago regarding the Iran operation, the grand jury investigation, or any of the legal proceedings connected to the Iran crisis. This category is the one that has produced the most significant reaction from the administration's legal team, because it directly targets the attorney-client privilege claim that the administration has been asserting over the personal attorney's communications. Judge Holloway's ruling on the privilege motion found that the crime-fraud exception applies to attorney-client communications made in furtherance of the concealment decisions documented in the grand jury's evidentiary record, and that those communications are therefore not protected by attorney-client privilege. The personal attorney whose presence in the Situation Room I documented in my previous analysis, present without a security clearance during a classified national security meeting, is now the subject of an enforcement order demanding the production of his communications regarding the Iran operation and the legal proceedings connected to it. That enforcement order, if complied with, will produce communications between a president and his personal attorney that a federal judge has found are not protected by privilege. In 23 years of federal criminal practice and analysis, I have never seen a presidential attorney-client privilege claim defeated on crime-fraud grounds and subjected to a federal enforcement order during the president's own term in office. Let me give you what is happening at those gates right now, because the physical and legal confrontation between federal marshals carrying enforcement orders and a sitting president's security detail is not a routine law enforcement moment, and its resolution in the next few hours will create precedent that no subsequent administration will be able to ignore. The federal marshals are presenting the enforcement orders to the Secret Service agents staffing the Mar-a-Lago security perimeter. The Secret Service agents are not lawyers. They are not empowered to assess the legal validity of federal court enforcement orders. Their mandate is the physical protection of the president and the security of the premises. They are not in a position to refuse entry to federal marshals carrying valid court orders. At the same time, the president's personal legal team is on the phone with every available legal resource trying to identify any remaining legal mechanism that could delay or prevent the enforcement orders from taking effect. I have spoken with 3 former federal prosecutors in the past hour. All 3 said the same thing. There is no remaining legal mechanism. The subpoenas have been upheld. The privilege claims have been rejected. The production order has been affirmed by the appellate court. The Supreme Court declined to stay it without a single recorded dissent. The enforcement orders are valid. The only question remaining is whether the administration complies or whether it defies a valid federal court enforcement order, which is contempt of court, which carries daily financial penalties beginning immediately, and which for individuals who are not the sitting president carries the possibility of incarceration for continued noncompliance. The contempt question, as it applies to the sitting president himself, is the constitutional question I referenced at the opening that has never been definitively answered in American law, because it has never previously been necessary to answer it. Can a federal court hold a sitting president in contempt for refusing to comply with a grand jury enforcement order? The answer in theory is yes. The Constitution does not grant the president immunity from contempt proceedings, but the practical enforcement of a contempt finding against a sitting president requires mechanisms that have never been tested and whose application would constitute a constitutional crisis of the first order. What the administration does in the next few hours will determine whether that untested constitutional question needs to be answered. Let me give you the three possible outcomes and their specific consequences, because this is the moment where the legal trajectory of the Iran crisis intersects with the constitutional architecture of the American presidency in a way that every outcome changes something fundamental. The first outcome is compliance. The administration produces the demanded documents and testimony. The enforcement orders are satisfied. The grand jury receives the evidentiary material it has been seeking for 21 days, and the investigation proceeds to whatever conclusions the documents support. This outcome is legally and constitutionally the most straightforward. It does not resolve the underlying criminal exposure. It accelerates the investigation's timeline toward conclusions that the documents will determine. Every experienced criminal defense attorney I have spoken with in the past week has said that compliance at this stage, while legally damaging, is strategically preferable to continued defiance, because the documents exist, they will eventually be produced, and the longer the defiance continues, the worse the obstruction exposure becomes. The second outcome is continued defiance with a contempt challenge. The administration refuses the enforcement orders, accepts the contempt finding, and appeals the contempt ruling to the appellate court and then to the Supreme Court, on the theory that a sitting president cannot be held in contempt of court. This outcome produces a constitutional confrontation that the Supreme Court will be required to resolve in the same 30-day window as the war powers' oral arguments. The Supreme Court would be simultaneously hearing arguments on whether the president had the constitutional authority to conduct the Iran operation, and whether the president can be held in contempt for refusing to comply with a federal court order demanding evidence about that operation. Two cases, one president, one 30-day window. The institutional pressure that scenario creates for the court is without precedent in American legal history. The third outcome is partial compliance with continued privilege assertion over specific document categories. The administration produces some materials while continuing to assert privilege over the categories most directly connected to the concealment decision and the financial conflict investigation. This outcome is legally creative and politically sophisticated. It allows the administration to claim it is cooperating with the rule of law, while protecting the most dangerous evidentiary material for as long as possible. Judge Holloway has already ruled that the crime-fraud exception defeats the privilege claims over the concealment-related materials. Partial compliance that excludes those materials would be immediately challenged and would likely produce a second contempt finding within days. Let me give you the specific implications for the Supreme Court oral arguments that are now 13 days away, because the federal marshals at Mar-a-Lago's gates are visible to every member of the Supreme Court, and the institutional context in which the 9 justices will hear arguments on presidential war powers has just changed in a way that no legal brief can fully capture. The justices will be deciding the constitutional limits of presidential war power 13 days from now, in a case where the administration has been found to have misled the court, where the war authority is being exercised in a context that a federal grand jury is investigating for financial conflicts, insider trading, and multiple forms of obstruction, where 7 allied nations have issued a final warning that has gone unanswered, where a unanimous appellate court has found that the operation constitutes intentional circumvention of the constitutional framework, and where federal marshals are currently standing at the president's private residence gate, waiting for compliance with a court enforcement order that the Supreme Court itself declined to stay. That is the institutional context of the oral arguments. It is not a legal argument. It cannot be briefed or responded to. It is the reality in which 9 human beings, who are also justices of the Supreme Court, will be deciding the most consequential war powers question in American legal history. Subscribe now. The resolution of the enforcement order confrontation at Mar-a-Lago will arrive before this day is over, and its outcome will determine the trajectory of every active legal and political proceeding connected to the Iran crisis simultaneously. Tell me in the comments, do you believe the administration will comply with the enforcement orders before the end of today? Or will it pursue the contempt challenge that would bring the question of presidential immunity from court enforcement into the Supreme Court on the same timeline as the war powers' oral arguments? I read every comment. My next analysis covers exactly what the documents in the 5 enforcement order categories contain based on everything the evidentiary record has revealed so far. Why the financial conflict category is the one the administration is most desperately trying to protect, and what compliance today would mean for the grand jury's timeline to potential indictments.